والسلام على رسول الكريم. As always, in the name of Allah, we send peace and blessings to our noble Prophet Muhammad sallallahu alayhi wa sallam. رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقهوا قولي. The dua of Musa and Sultan is always beautiful, where he's being told, go to Pharaoh. And he's like, Ya Allah, like, you want to go to Pharaoh, like Pharaoh? And so he recites this dua that is, Rabbi Shrah li Sadri, oh Allah, purify my chest. ويسر لي أمري, make my task easy for me. واحلل عقدة من لساني يفقهوا قولي. Musa had a speech impediment. And so he told him, remove that speech impediment so that they may understand my speech. So before we get talking, again, a lawyer, we love our disclaimers, we love our legal notices. So this is not legal advice. We are doing education of the community. There's no attorney-client relationship that's created here. And you should always, again, seek advice from an attorney. What are the things we're going to be covering today? What is an estate? What is the importance of having an Islamic will? What are the Islamic inheritance laws? And why are they the way they are? The importance of having a will under Texas law. What are the consequences if we don't have a will? And then taking care of our most important asset, our children, right? How do we make sure that they are taken care of? What are trusts? Why do people use them? And then we'll close off for a few minutes talking about OPAW or endowments in the future Muslim institutions. So, what is an estate? I'm talking about estate planning. What's an estate? Everything you own? Yeah, basically. Your total of a person's property, entitlements, and obligations. So property, so real property like land, and then personal property. Anything that's movable property is called personal property. So that's cars, cash, jewelry, artwork, securities, stocks and bonds, copyrights, patents, trademarks, goodwill. Those are all in the estate. So when we're looking at Islamic estate planning, there's 4 big principles that we're looking at. What are your things, right? That's one everyone always gets. Yeah, your things, where do they go? That is one part of estate planning. We're also looking at your family. Do you have minor children? Do you have adult children with disabilities? Do you have adult children who maybe are not responsible, who need additional support, right? So that's something that we need. Are you supporting your parents, right? And you want to continue that. That's something, well, God forbid something happens to me. I don't want my parents to feel the impact of my death, right? So I want them to continue living at the status that they are right now with my help and support, if that's what's happening. The third thing is your comfort. If I can't make decisions, who makes decisions for me? Who makes financial decisions for me? Who makes medical decisions for me? And what are the guardrails that I want them to have? And lastly is if you have a business, what do you want for that business? I want my family to be able to extract assets from that business. I want to make sure I have a business partner that I am not taking away their rights and they're not taking away my family's rights. I want to make sure that my family can either keep running the business, they can extract assets from the business, they can sell the business, they can do whatever, but like again, that business there needs to be planning done so that that happens. And again, that means that sometimes we're having really uncomfortable conversations, but again, that's very necessary. So when, in Sheikh Abu Sulaiman's book, Allah Loves, his first chapter is on taqwa, which he translates as piety. But it was also commonly translated a lot of times when I was a kid as fear of God. Or again, later on, it became like consciousness of God, being aware of God. And then not doing anything that is displeasing to Him. When we look at the first verse of Surah Al-Baqarah, again, it is this is the book, there is no doubt in it, and it is a guide for those that are mindful of Allah. So what does taqwa have to do with estate planning, Lubabah? So there's a verse in the Quran, verse 183, it says that, again, during Ramadan you hear this verse a lot. يا أيها الذين آمنوا كتب عليكم الصيام كما كتب على الذين من قبلكم لعلكم تتقون. Right? Oh, you who believe, كتب عليكم, fasting was prescribed for you, like it was prescribed for those before you, so that you become God conscious, so you become a person that has piety. 3 verses before that, verse 180, Allah says, كتب عليكم إذا حضر أحدكم الموت إن ترك خيرا الوصية للوالدين والأقربين بالمعروف حقا على المتقين. It is prescribed that when death approaches any of you, value, a will should be made in favor of parents and immediate family with fairness. And this is an obligation of those who are mindful of God. And there's a lot of hadith that talk about estate planning. Right, there's a lot of verses that talk about it, but one, I'm going to mention just a couple of them quickly. One of them, the Prophet said there, they say, "Oh, Abu Hurairah, learn about the inheritance and teach it, for it is half of knowledge, but it will be forgotten. This is the first and the only thing with determination." This is one of the most divinely detailed rulings in the Quran. It is divinely legislated. It is a mechanism of ensuring that the wealth transfer to rightful heirs, preserving a just society. You want me to talk just louder without the microphone? Or should I just keep talking and then hopefully okay. So there are, again, many verses that talk about inheritance. One of them is for men, there is a share in what their parents and close relatives leave, and for women there is a share in what their parents and close relatives leave. Whether it is little or much, these are obligatory shares. Before Islam, we know that women were not allowed to inherit. A lot of times they were a part of the inheritance. Like there's a Sahabi, Sa'd ibn Rabi'ah, who died in the Battle of Uhud, and his brother came and took his entire estate because he only had daughters. The wife didn't just sit. She went to the Prophet ﷺ and was like, "Ya Rasulullah, you know, my husband died during the battle. His brother came and took everything. What do I do?" And the Prophet didn't have an answer because there had been no verses revealed. And so she kept coming back. And then this verse was revealed that men have a share and women have a share. And the uncle was ordered to give 2/3 of the money to the daughters, 1/8 to the wife, and then he could inherit whatever was left. How many verses in the Quran talk about the details of inheritance law? We said this is the most specific area of law, right? You're told Aqim as-salah, but you're not told, you know, this is how you stand, based on Allahu Akbar, how you hold your hands, going into the ruku, standing up. With inheritance, you are told exactly who gives what and when. How many verses? Just guess. A page, okay. A page could also be like Ahad, or it could be like 3 verses. 3 verses that actually talk about the details. And they're all in Surah Nisa. Again, 2 more hadith before I go into the verses. It's a duty of a Muslim who has anything to request to not let 2 nights pass without writing a will about it. So if you have anything, a bank account, a car, a house, anything, 2 nights, jewelry. The last hadith, a man may do good deeds for 70 years. Abu Hurairah narrates 60 years, but it just means a lifetime of good. If he acts unjustly when he leaves his last testament, the wickedness of his deed will be sealed upon him and he will enter the fire. May Allah protect us all. If, on the other hand, a man acts wickedly for 70 years or 60 years, but is just in his last will and testament, the goodness of his deed will be sealed upon him and he will enter the garden. May Allah make us all of those. So again, you have to have a will, you have to be truthful and fair in your estate, towards your parents and your family. And living here in America with intestacy laws, which are the laws that happen if you do not have something written, it becomes fun. Some scholars say obligatory to have a written will. So Al-Fara'id is the subject of the instructions concerning inheritance. It involves one of the rules for dividing inheritance and distributing it so that every share receives his or her perfect share. Who inherits? Spouses always inherit. Parents always inherit, children always inherit. If you don't have parents, then grandparents may step in and inherit in space of the parents. If your children have predeceased you, then grandchildren in certain circumstances can step in and receive the inheritance. If you don't have those people, especially not a father, grandfather, son, or grandson from a son, that's when siblings can inherit. And then if you don't have any of those, that's when maternal aunts and uncles can always inherit. Who doesn't inherit under Islamic law? Non-Muslims, someone who has, if we have non-Muslim spouses, non-Muslim parents, Muslim children, they all protect us. They would not inherit under Islamic law. You can leave them something in your bequest, which is your wasiya, but you have up to 1/3 of your assets you can do anything with. So you can leave that to non-Muslims. And apostate, someone who leaves Islam, someone who kills either directly or indirectly someone who he inherits from, and people who die simultaneously, like a family in a car accident, and there's no way to determine who died first. There's different types of heirs. There's those heirs that received fixed shares, meaning you get your 1/8, 1/4, 1/3, 2/3, 1/6. Like the mother, the wife, the husband, maternal half-brother, daughters, they all receive a fixed share. There's some people that receive the residuary, which is whatever's left. So those small relatives, like the son, the brother, the uncle, cousins, they would all receive the residuary. So if there's anything left, and there's a male relative, they would just get the residuary. And then sometimes, like the father, the grandfather can get a fixed share, and then whatever's left. So the first verse is verse 11, so it's Nisa. And again, it's verses 11 and 12, and then the last ayah is Nisa, verse 187. So verse 11 says, God commands you regarding your children. The share of the male will be twice that of the female. But if you leave only, twice the female. If you leave only 2 or more females, their share is 2/3 of the estate. But if there's only 1 female, her share is 1/2. So your son receives double what your daughters receive. If you only have daughters, 1 daughter receives half, 2 or more daughters share in 2/3. Why does a daughter receive half? Why does a daughter receive half? Why does a brother get double? Yeah.
Usually the guy has a lot of responsibilities. He has to take care of his the women in his family, but the woman doesn't have that obligation of spending on their family.
Who are the women in his family? Wife. Who else?
Sister.
His sister. His sister. So my brother gets double my inheritance. My inheritance goes straight into my investment account, being invested and growing. My brother has a religious obligation in front of Allah to spend on me. My husband has to spend on me. If I'm not married, my dad has to spend on me. If he's not able to, my brother has to spend on me. I have zero obligation in front of Allah to spend a penny. Everything I spend on my family, on my children, on my parents, that is all sadaqah or zakat. I can give zakat to my husband cannot give zakat to me. Sorry, the mic keeps going out. But a woman can give zakat to her husband cannot give zakat to her. So if you're a woman and you are contributing to your household, make sure you have made your intention that everything I spend is sadaqah. We're spending anyway, and so just make your intention, and then you're getting these. A woman doesn't have the expense of jihad. She doesn't have the expense of maintaining her family, having to pay blood money, right? Islamic law Sharia is not aimed at elevating one gender over the other, but it's to create a stable and balanced society. Can you equalize the shares? I get that asked all the time. Yes. With the permission of the shares, of the inheritors. So if my brothers are like, yes, you all can get the same as us, alhamdulillah. If one brother's like, no, then he can get his full share and the other brother can give us equally. And then there's other things that you can do, such as gifting while you're alive. If I'm alive and well and healthy, I can give whatever I want to. And families do that sometimes. Like they'll give their marital home to their daughters to make sure that they always have a place to live. Or they will give them a life estate, meaning you can live in the house without paying anything for the rest of your life upon your death, or when you want to leave the house, that's when it gets divided amongst the rest of the siblings. While I'm alive and well, I can do all of that without violating Sharia. So verse 11 continues, we talk about children, it talks about parents next. Each parent is entitled to 1/6. So mom and dad receive the same. There's no difference. Mom and dad both receive the same. If you leave offspring. So if you have kids, your mom and dad both get the same. But if you are childless and your parents are the only heirs, then your mother will receive 1/3. But if you leave siblings, then your mother will receive 1/6 after the fulfillment of the bequests and debts. So if the deceased left children, mom and dad each get 1/6. If there's no children, mom gets 1/3. And then silent to dad, meaning dad gets the residuary, right? We talk about fixed shares and residuary. And then if deceased has brothers and sisters, then mom gets 1/6. Again, dad has to support all of those siblings, and dad gets the rest, and the siblings do not inherit. Verse 11 closes out by saying, be fair. Be fair to your parents and your children, as you do not fully know who is more beneficial to you. This is an obligation from God. Surely God is all-knowing, all-wise. Right? We know that when a person dies, your good deeds all come to an end, except for 3, sadaqah jariyah, ongoing charity, beneficial knowledge, and a righteous child who prays for you. That child, that might be the one that you're like, I want to disinherit them because they're not doing anything. That might be the child that's making dua for you, that's going and doing umrah on your behalf, that's doing hajj for you, right? And so Allah tells us that you don't know what's going to happen. These are my rules, follow them. So then verse 12 comes in and it talks about wives and husbands. So you will inherit 1/2 of what your wives leave if they are childless. But if they have children, then your share is 1/4 of the estate after the fulfillment of the bequests and debts. And your wives will inherit 1/4 of what you leave if you are childless. But if you have children, then your wives will receive 1/8 of your estate after the fulfillment of the bequests and debts. So the husband receives 1/2 of the wife's estate if she has no children, and he receives 1/4 if she has children. The wife receives 1/4 of the husband's estate if he has no children, and then receives 1/8 if he does have children. If you have co-wives, they would share in 1/4 or 1/8. Verse 12 closes out by talking about someone who is kadada. Someone who's kadada is someone who does not have any ascendants or descendants, no parents or grandparents, and no children or grandchildren. And if a man or a woman leaves neither parents nor children, but only a brother or a sister from their mother's side, they will each inherit 1/6. But if they are more than one, they all will share 1/3 of the estate after the fulfillment of bequests and debts without harm to the heirs. This is a commandment from God, and God is all-knowing, most forbearing. So again, no ascendants, no descendants means that they are kadada. But if they have maternal brothers and sisters, they receive 1/6 each if there are 2 siblings. So again, they receive the same. Maternal half siblings, brother and sister receive the same, 1/6. If there are more than 2 siblings, they share in 1/3. Those are the verses that were revealed. So the verses after it talk about Lubabah. These are the limits that are set by God. Whoever obeys God and his messenger will be admitted into gardens under which waters flow, to stay there forever. That is the ultimate triumph. Allah makes us all of those. But whoever disobeys God and his messenger and exceeds their limits will be cast into hell to stay there forever. They will suffer a humiliating punishment. May Allah protect us. So the Sahaba were like, that math does not make sense. We talk about spouses, we talk about children, we talk about parents, but the siblings doesn't make sense, right? The math does not math. And so they kept asking, including Lubabah and Umar about kadada. So verse 176, which is the last verse in Surah Nisa, was revealed. And it's funny because it starts by saying, yes, they are asking you for a fatwa, O Prophet. Say God will give you a ruling regarding those who die without children or parents. If a man dies childless and leaves behind his sister, she will inherit 1/2 of his estate, whereas her brother will inherit all of her estate if she dies childless. If this person leaves behind 2 sisters, they together will inherit 2/3 of the estate. But if the deceased leaves male and female siblings, a male's share will be equal to that of 2 females. God makes this clear to you so you do not go astray, and God has perfect knowledge of all things. So again, this is very similar to children, where one sister receives 1/2, 2 or more sisters receive 2/3. Both brothers and sisters, the brother receives double what the sister receives. a woman dies leaving only brothers, he or they inherit everything equally. And again, Allah closes out by saying, God makes this clear to you so you do not go astray, and God has perfect knowledge of all things. One of the things that's mentioned a lot in these two verses are wasiyah, which is a bequest, or dayn, which is debt. And it's mentioned 4 times in these verses, and it just stresses the importance of fulfilling the deceased wasiyahs and paying their debts. Scholars say that wasiyah is mentioned first because people take that more lightly, right? A debt, people are like, oh, we have to pay the debts. But if someone said, go give 10K to someone, they're like, well, maybe, I don't know, right? They might not take it as seriously, but it's mentioned first, as scholars say, to emphasize the importance of it. There was a Sahabi who was on his deathbed and freed his entire estate. It was only 6 slaves. He freed them all. His wife went to the Prophet. Again, something happened. The wife didn't just accept it and say, okay, this is, go be patient and just sit. Right? She went to the Prophet and was like, Ya Rasulullah, his entire estate was 6 slaves, and he freed them all on his deathbed. What can I do? Prophet freed 2 of them and left to 1/3 of the estate and kept 2/3 for the family. So up to 1/3 of the estate can be given to charity or those that are not provided for as heirs under Islamic law. So a non-Muslim wife or parents, adopted children. If you have a special needs child and you want to leave them more with the permission of the inheritors, you can do that. Or anything else for good, or anyone else for good. Inheritance is a means Allah made for supporting one's nearest family, and one should not rob them of this opportunity or cause them to fall into poverty. There's also a hadith that says, one of those Sahabi was like, I have one daughter, can I give, my estate in charity? And the Prophet was like, no. He's like, what about my half? He's like, no. And then he said, what about 1/3? And the Prophet said, you can do 1/3, and 1/3 is a lot. So what happens when you die? Under Islamic law and under Texas law. Under Islamic law, if you borrow something, it gets returned. If you have burial expenses, they come out of the estate. If you have any debts to people, they are paid. If you have written in your wasiyah that I have debts to Allah, I did not fast days from last Ramadan. I have not gone and done Hajj, even though I have the physical needs and the financial needs to go. I didn't pay my zakat for last year. I didn't finish paying it all. Hanafi and Maliki say that you can pay this if it's written in the wasiyah and only up to that 1/3 of the estate. And then your wasiyah, that 1/3 of the estate. And then the assets get distributed according to Sharia, the first of the topic. Under Texas law, probate is what happens. Probate is a legal process where a court determines if there is a will, if that will is valid, and then appoint someone to distribute the assets according to that will. If there is no will, then it passes according to Texas law, and we will talk about what that looks like. But their goal is to appoint an executor, find any creditors, pay debts, pay the income and estate taxes, and distribute the assets. We talked about this earlier. Again, we're looking at your assets, we're looking at your family, we're looking at your comfort, and we're looking at your business. So some things to consider: making a will, consider making a trust, making healthcare directives, a financial power of attorney, protecting your children, so appointing a guardian for them, considering life insurance potentially, understanding any tax consequences, which isn't an issue anymore after last year unless you're ultra high wealth, and then covering any funeral expenses or final arrangements, and then long-term care. So then you have to think about, what are my duties under Islamic law? What are my assets? What are my liabilities? Who, if anyone, will contest my will? And those are the reasons why this all needs to be written. A healthcare directive. What do I want to happen if I cannot make healthcare decisions for myself? Who do I want to make the decisions? What are the decisions I want them to make? I don't want to be put on a ventilator if I have terminal illness and the doctors are like, you have 6 months or less. I want pain medication and I want to go as gently as possible. Right? What are those decisions, and what are the guidelines that I want to put in? What if I become mentally incapacitated? What happens then? Who makes sure that the bills are paid, that my kids are taken care of, that their tuition is paid, that the mortgage is paid, right? Again, you want to make sure that you give as much guidelines to your family so that things are easy if this happens. So a lot of people call and they're like, we don't have anything, we have our house, it's a bank account and a car. Do I really need to do a will? Do I need to make a trust? So again, if you don't have anything, you do have a plan. It is the state of Texas's plan. It is what our legislature has legislated and said, this is who inherits, this is who gets, and this is the amount that they get. And you have to go through the probate process, which is designed for two reasons. One, to notify and pay creditors. The second is to ensure your heirs receive your assets. So your heirs will receive it, it's just not in the shares that are compliant with Sharia. This is a short graphic of the steps that have to go through when you go through the probate process. Because it is to notify creditors, it is a one-size-fits-all process, it's a public process. You know, it has to be published in the newspaper or published on the courthouse steps, or and people are told that if you think you have debts owed to you, come on this day at this time, and people show up, and it's, again, 6 months to 2 years where your assets are frozen and your family does not have access and they cannot move on. And in Texas, the problem is you have to hire an attorney to go through this process. In other states, that's not the case, but in Texas, you actually have to hire an attorney, and it's more than you would pay to do an estate plan with an attorney. And the last thing is it's public, like nothing is filed under seal, so everyone, you can go look up anyone's estate if they've gone through the court process. You can look at their will, you can look at what they gave, how much they gave, who got what, all the debts. It's a public airing of the finances. So again, a government will appoint an executor who will divide the assets. That pay will come out of your estate. Your heirs will get more or less than what they're entitled to. That's if you don't have a will. If you have a will, it will go according to what's in the will, but you have to go through the court process anyway. Most cases, if you like downloaded the ISGH will or gone to My Lucia and filled out a will, if you have not taken additional steps, you will still be going through this probate court process. And then again, the scariest thing is that if we haven't done our own planning, a judge that does not know us, our families, our values, our children, will be making those decisions. They'll be deciding who the guardian is, who takes care of them. And so minor kids are unable to inherit money until they're 18. I don't want my 18-year-old to get a lump sum check. I don't think that his prefrontal cortex is not fully developed. He is not going to use it in the wisest way. He might be taken advantage by people, he might be taken advantage by his friends who are like, you have money, let's go do a business together, and the business fails, and he's out of his inheritance, right? And so I want him to have support to help him to make these decisions until he is wise enough. And again, and people ask me, they're like, is that Sharia compliant? I'm like, there's two verses in the Quran that I send people to. One is, the Quran says, do not give your money to foolish people. Right? Do not give your money to foolish people. My 18-year-old is a foolish person. He is. That's just the reality of feeding children in America right now. Right? And the second verse is, if you have money for orphans, it says, test them. Before you give them their wealth, test them. See, are they ready? Are they going to use it in a well way, or are they not? And if they're not, then you hold on to it for a little bit longer. But if they are, then have them out. So again, a judge will decide who gets what. Like my sister, subhanAllah, had surgery today, and so she sent me a list of all of her assets and all of her accounts. I'm like, why do you have your 6-year-old as payable on debt on your bank accounts? First, I'm proud of you for having a payable on debt, but a 6-year-old cannot inherit. Like, you have to go through the court. Please change that. And again, the judge chooses who will be the guardian, who will raise the children, and who will take care of the finances for them. We have a Texas Department of Unclaimed Property that has over $6 billion in it. And so if our family doesn't know where our money is, the bank will just freeze the money and hold it for a couple of years, and then they will send it to the tax property. So one of the important things to do is to make sure that usually spouses will know where each other bank, but your siblings know where they bank. Like my sister literally sent me a bunch of things this morning, and I was like, oh, I didn't know you had this account here or there, but now I have access, so I know, right? And so we have to make sure that people know where everything is, so they know how to get it. So creating a detailed spreadsheet of where my assets are, where the account number is, who I reach out to, what is that beneficiary designation listed on there, to make sure that those things go according to the law. So we talked a little about the Texas plan. I'm just going to go really high level on Texas law and separate versus community properties as developed in Texas. Separate property is anything that is owned by a spouse before marriage, or I got it during the marriage by gift or inheritance or certain personal injury claims. That is separate property that's owned by me. If I get that inheritance and I put it in the joint bank account, your spouse can claim that it is now community property because you co-mingled it. Like if I have my house that I inherited and then I live with my family and my spouse and then I put his name on the deed, it's going to be very hard to claim that that is my own separate property. So if you inherit something or you receive it as a gift, make sure that you're keeping it in a separate account. Make sure that you account for how you're using it and how that money is. It's really important to teach our children this, especially. Community property is all property acquired by either spouse during the marriage that is not separate property. Any real estate owned by either property during the marriage is presumed to be community property. And so any property acquired during the marriage is treated as community property, i.e. joint, and therefore it is liable to be split in half. So again, if you are a single person with or without children, if you don't have children, then it goes to your parents equally, 50-50. If only one parent is alive, if you have no siblings, then that parent receives everything. If you have children, then parents do not inherit under Texas law, and it all just goes to your children equally. Grandkids can take their parents' share. If you're married, with or without, if you're married, your surviving spouse will inherit all of your community property if the children are all from the same marriage. Right? So if they don't have separate children, you don't have any separate children, you would inherit everything from that community. Otherwise, you get 1/2 of the community interest to your children, and the spouse only keeps his or her half interest. If you have separate property, then the surviving spouse receives 1/3 of the separate personal property, and a life estate, meaning the right to use the property until his or her death, and 1/3 of the property. There's a lot more detail, but we're not going to go into it. So here's a simple example. If you have no will, you've got a deceased person, there's a spouse, and there's 2 kids. Who inherits under Texas law? There's community property and separate property. Who gets community property? It comes from the same marriage. The spouse. The spouse gets everything that was earned during the marriage. What about separate property? What do they get? They get 1/3 of any separate personal property, which is again income movable, and they get a 1/3 life estate, meaning they can live in. If you own 3 houses that are separate property, they can live in one of those houses for the duration of their life, but the ownership still stays with the children. What about her son-in-law? Who inherits?
They all inherit.
Okay, what do they inherit? What are the bonds? If the husband or wife, I left it vague. Husband gets 1/4. Since there's kids, if there are no kids, you get 1/2. Wife gets 1/8. because there are children. What do the kids get? Yep, so 1/3, 2/3 if they're son and daughter. There's 2 daughters, 2/3, excellent. And if it's 2 sons, 50-50. Excellent. What if there's parents? Does it change anything? Under Texas law, nothing changes. Parents do not inherit because there are children. What about our Islamic law? 1/4 to the wife, 1/8 to the husband. 1/4 to the husband. If it's the wife estates, the wife gets 1/8. Mom and dad receive 1/6 each, and then the kids receive whatever is left. 2 boys equally, 2 girls receives 1/3 each. A girl and boy, she receives 1/3, and he receives 2/3 of whatever is left. What do you need to do to create a valid will in Texas or under Islamic law? Any person of sound mind who is at least 18, it has to be in writing, it has to be signed by the testator, who's the person who's writing the will, or at my direction. So if I can't write, I can say, can you write this, can you sign this for me? And it has to be attested to, meaning witnessed by 2 competent witnesses who are at least 14 years of age, who sign the will in the presence of the testator. You cannot, once you've done your will, you cannot strike out any portion. So if I've left Sadaqah Jariyah to a masjid and then I got into a fight, so I'm like, they get nothing, so I go to scratch it out, not valid. You have to actually re-execute the will. Under Islamic law, you don't have to be 18. If you have anything, you can write a will. So this is only in Texas. Yes?
The people that are 14 years, is it okay if they're related to the person?
They have to be uninterested, I should add that. So meaning they cannot be related, they cannot be someone who inherits. So my son or my daughter cannot witness my will. But if it's like another 14-year-old, yes, they can sign my will under Texas law. Texas. Again, to create a valid will, you've got the power to give according to Islamic law and Texas law. If you don't have a valid will, then it falls to the rules of intestacy, which is kind of a will, falls to the laws of the court, and then someone will have to go to court to get guardianship over any minor children or any adult disabled children. And if you have written out what you want to happen, you will have no say in that. So what is a trust? Trusts are commonly used in estate planning context and are also used in asset protection strategies. It's designed to ensure that assets are managed and or distributed to beneficiaries in accordance to the terms of the trust instrument. So a trust you can think of as a legal entity, like an LLC, like a corporation that you're creating, and you write out who can manage this. Well, I'm alive, usually it's me. Upon my death or incapacity, you can write out this person manages. If they're not available, then this person. If they're not available, then this person. You can write out who the beneficiaries are and those like who benefits from this trust. And while I'm alive, it's me. Upon my death, it becomes my parents get a share, my children get a share. If something happens to all of them, then my siblings get a share. So one of the main goals is to avoid the hassles and the expense of the probate process, and reduce the risk of it being encumbered by unnecessary taxes, as well as protecting heirs from themselves, especially when there's a concern of financial immaturity, young age or immaturity, or addictions or alcohol or disability. So again, it's a legal entity that holds assets for many reasons. It's designed to ensure that the assets are managed and distributed to beneficiaries in accordance with the terms of the trust instrument. There's 3 parties involved. One is the grantor, also known as the trustor or the settlor, and that's the person who creates the trust. The trustee, which is the person or the entity who controls and manages the assets in the trust, and then the beneficiary, who benefits. And again, it can be the same person. So I am the grantor, I created my trust. I'm the trustee, meaning I manage the trust while I'm alive and well, and I'm also a beneficiary, so I can do whatever I want to with whatever is in there with no regard to anyone else until I pass away, and then it stops being a revocable trust and it becomes an irrevocable trust where you have to do exactly what I say. So one of the other important things about a trust is you have to fund the trust, meaning you have to actually put the assets inside of the trust. So things like the marital home or the residence that you live in, you retitle it into the name of the trust and you record that with your recorder's office. If you have cash or bank accounts or real estate or a paid off car, you can make the trust the beneficiary. So if you have an account with a bank account, so you can actually make the bank account payable on death or transfer on death to the trust. So upon my death, my sister grabs some death certificates, she goes to the bank and she gets access to the money and she puts it into a new bank account in the name of the trust. Same thing with retirement, life insurance, cars, any other assets for the most part. You can pass them all outside of probate if you've taken the necessary steps. There's a lot of different types of trusts. The two big ones are going to be a revocable or an irrevocable trust. A revocable trust is created by the grantor, who also initially serves as a trustee, and it can be changed or altered or modified or revoked anytime during their lifetime. An irrevocable trust is created by me, but it cannot be changed, altered, or modified or revoked once it's created. Once the assets are placed into an irrevocable trust, it is managed by the trustee in strict accordance with the terms. Some of the benefits, again, a will goes through probate, which is that public court hearing, takes time, takes money, hire an attorney. A trust goes outside of court. If you have funded it, if you have put your assets in it, it goes outside of the court process. You just need a death certificate. You can ensure that parents or grandparents are supported, taken care of, that your wife and your daughters are supported. Again, it used to be a tool to avoid the estate taxes. Texas does not have estate taxes, and the federal tax limit was just go down to $5.75 million in January. But in the one big beautiful bill last year, it's been a permanent exemption of like 16 million each. So unless you have assets over 32 million, you do not have to worry about estate taxes in Texas. Yes.
So I had a question. Let's say there's a trust that's like your parents made a trust for you. Let's say, God forbid, something happens to them in terms of like they're still alive but not mentally functioning. And does the trust only work that they're after they pass away?
There should be versions in it that say that if they are incapacitated and have terms for what that means. So like after one doctor or two doctors say that they're incapacitated, they stop being the trustee. If there's co-trustees, then again, the other parent will be able to manage that. If they're both incapacitated and they'll protect all of their families, then whoever that successor trustee is can make those, has to make those decisions. And when we talk about estate taxes, it's not really a big deal anymore. If you do give gifts while you're alive, there's gift tax on gifts that are 18,000, probably 19, closer to 20,000 right now. So if you're gifting someone less than that amount, you don't have to do anything. If you're gifting someone over that amount, you do have to file a gift tax return when you do your taxes in April. So then what happens if you're incapacitated, right? Like we just spoke about, right? If you're unable to handle your own personal financial affairs, it depends on the circumstances. But who's going to make sure that the mortgage is paid, that tuition is paid, who's got access to your account, what medical decisions are people making, can they put you on a ventilator, life support independently, who takes care of my kids, what happens to that if, God forbid, anything happens. So some of the things that you should do, especially if you are a parent, designate a guardian. If less than law, I pass away or I'm incapacitated, this is who watches my kids. If they're not available to this person, if they're not available to this person, If that person who I want as guardian does not live within 20, 30 minutes of my house, I need another document that says this is a short-term guardian. This is who can come to my house right now and spend a couple hours, a couple of days until my family can get from wherever they are. Something that is necessary for all of us to have. What if I'm incapacitated? Who do I want to take care of me physically or me financially, my financial estate? You can decide that and weigh it out. A financial power of attorney or a durable power of attorney lets you choose who can pay your bills, who can access your bank account, talk to your insurance company, talk to your employers, sell or buy property, do whatever that you can do if you've again written it out. A medical power of attorney or a healthcare proxy lets you choose a person to make medical decisions for you. If the doctor says you cannot do so, you can also draft a living will or a healthcare directive that says, what do I want to happen if I have a terminal illness, or if I can't make decisions for myself, what do I want to happen? The last thing I'll talk about here briefly is just gifting. While I'm alive and well, I can do whatever I want to. I do not have to give my son and daughter 2 to 1. Right? That is only if I am dead and inheritance law comes in, or if I have muddled and milk, if I have a terminal illness where the doctors have told me, or I'm on my deathbed, at that point I have no rights on my wealth. While I'm alive and well and healthy, I can do whatever I want to. I can give my house to my daughter. Period. Done. My son can't say anything. But I can give her life estate. I can give her jewelry and buy it and give it to her. Right? I can get my life insurance and put it just in her name. While I'm alive and well, I can do whatever I want. It's only upon my death that these rules come into play. So non-probate transfers is the last one I'll avoid to wealth or accountants. A non-probate transfer is things that pass outside of probate, outside of the court system. So joint ownership of property, if it says with the right of survivorship, which is not the default in Texas. So if you look at your deed to your house and let's say you own it with your spouse, it is unlikely that it says joint ownership with right of survivorship. That means that you own half and your spouse owns half. Something happens to one of you, the other one still only owns half. If you own it with joint rights, right of survivorship, when one person passes away, the other one owns all of it. It will either say as husband and wife, or it will say with right of survivorship. If it doesn't say with right of survivorship, you need to give you extra steps to make sure that the spouse gets all of it upon death. So a lot of times what we do in our wills and trusts is we gift the house to each other. I'm alive and well, I can gift my house to my spouse. So that my spouse does not have to leave the house. If my spouse has not worked, that she has not had paid work, let me be very specific, because she does all the unpaid labor in the household a lot of times, I can gift her my retirement accounts. I can gift her my life insurance so that she can live with her dignity and not be beholden to children. Her own children, but again, so she has her comfort and she can live the way she wants to. So you can have this joint ownership on bank accounts, houses, cars. You can also have a beneficiary designation. So if you started a life insurance or an IRA or any employee benefits, they ask you, who is your beneficiary? Those are all things that pass outside of the court system. So you want to make sure that your spouse is listed. You do not want minor children listed because they cannot inherit. The other thing is that you do not want not just minor children, but children who might be, my son is 18, but I don't want him listed, right? I don't want him to get it. If that's something happens to me tomorrow, I don't want him to get it. So like, I had my sister listed before I set up my trust. I had everything listed in my sister's name because I trusted that she would be able to manage it, invest it, take care of it, making sure that everybody gets their rights, and she would take care of them with it.
Two questions. When you're closing a house, do you bring that up with that person, or do I have to go to the law firm to get that,
If you're buying the house, tell them, I want this done
with the
with,
clause?
yeah, with right of survivorship. Husband and wife with right of
I
survivorship.
can add that, I have to go to a lawyer or a law firm?
If you're just buying the house, yes. If you've already closed and you have the deed, it's already been recorded, then you just need a new deed.
The question was that, let's just say there's a lot of assets besides the house, like you mentioned, retirement accounts, and, usually the typical, the husband owns them, and then he has the wife has custody. From an Islamic standpoint, you mentioned that it was, I think, an eighth that goes to the wife. So how does that work out from an Islamic standpoint? Because, I'm just struggling to understand, like, yes, you give it to the wife, but are you saying, are you justifying by saying, like, hey, she's doing a lot of the things in the house that, she's not getting paid for? Is that a way to kind of reconcile that?
So there are some, no, so gifting while you're alive, whatever you want to. There are no restrictions on it. So you can just make your pension, my retirement account is a gift to my wife, my life insurance is to my wife, period, done. But then, sorry, every time I move and I Google up. The other thing is, when you're looking at wife, husband and wife, there are some scholars that say that the family unit is like a shed, like a company. And so even if she is not working outside of the house, she is entitled to half of everything. Right, so the default in a lot of our wills and trusts, and I have to ask this question, which is totally, again, awkward conversations, like whose money is it? Who owns it? Right? Do you own 50-50? Because if so, wife gets 1/2, plus she gets 1/8 from the second half. So there's some things that you gift outside of the estate. So like you gift the house outside of the estate.
When you say gift, are you saying you're giving ownership to your spouse while you're alive, or it's a condition that, hey, I'll give you this ownership when I pass away?
So we usually gift to each other.
Like, I'm giving you the...
And I'm giving you my half, and she's giving you her half.
While we're alive.
While we're alive right now today. We are alive and well. I'm gifting you half, you're gifting me half.
And then she owns the whole house then? Technically. Or I own the whole house. How do you know that? Technically.
Technically speaking, yes, there's a little bit of gray. There's some scholars that are like, that doesn't work. Chef Joe Radford was like, it's totally fine. I was like, I'm like, I'm good. Yes. Yeah.
I guess, honestly, that was one of my big questions about the house. So as far as but with the gifting, I guess, is that something that you have to put in legal writing, like the house to only remind you, or is it just like we verbally saying like, oh?
I would write it because, again, not families, right? So I would write it down, and we'll talk about writing it down.
Something that you can like put in your will that
A
this is
sentence, I am gifting you, we are gifting each other the house, I am gifting you my retirement accounts. And then that comes out of the estate, so you're not, when you're looking at the 1/3, we'll see, when you're looking at 1/6 of parents, that does not get calculated in it. It's everything else that gets calculated. Yeah, I'll stop doing it, I promise.
if any asset is part of the trust, is it true that you can never sell it, or is it just for a living trust?
It's for an irrevocable trust. If it is an irrevocable trust, I can do whatever I want to. Even if it's an irrevocable trust, it depends on, the trustee can sell it. So if I created an irrevocable trust for my children, I put assets in it, I can sell that as a trustee. But the money isn't used for my benefit, it's used only for the benefit of the kids. So it just depends on how you created it. But again, for my irrevocable trust, but I'm not selling it as Lubabah Abdullah an individual, I'm selling it as Lubabah Abdullah the trustee of the Lubabah Abdullah Irrevocable Trust. Yes.
So I was going to piggyback off this question a little bit. So I know there's like inheritance laws already set in place Islamically. Can you divert away from that, or is that like?
If everyone agrees.
So all the inheritance people have to agree. I see.
So my parents want to give my brother extra because he has special needs and he can't take care of himself. So whoever my brother lives with, they should get a large share of the inheritance. We all agree.
So if
You can have them write a disclaimer right now. I have some clients who actually sign disclaimers saying, we don't get anything after the death of the first parent. We only inherit when both parents pass away. Or we want our daughters to receive equal. Or if siblings inherit, because you only have daughters, you can write in there, hi siblings, you inherit, this is your share, I want you to disclaim, please. They can say yes, or they can say no, but you can make your wishes known, again, if you're planning in advance.
So if you, let's say if you have a two-parent household, 6 siblings, let's say, and so the youngest, okay, nice. So yeah, let's say the youngest is like a 5-year-old child. You still have to get their approval.
You get the guardian's approval, because they can get it.
But the guardians are the ones that are setting the term. No? Like the parents want, let's say the parents just want to leave everything to the eldest. How would that work?
They would all have to agree, and I would tell the parents that's cool. Because we have the hadith of the Prophet where the man was like, come witness, I'm giving my son this amazing gift. And the Prophet's like, do you have other children? And the man is like, yes. He's like, are you do the same thing for them? And he's like, no. He's like, no, that's cool. Again, without reason or, again, my parents aren't giving everything to my brother that has special needs. They're giving him like a larger portion. They're giving him one retirement account or one investment asset. Yes.
So, if you have children, you said that, and there's a child who always, would I have to give that person best than the others, or they have to, you know as well, know that he's gonna get less because ongoing support has been.
Did you tell him that that was a, did you tell him that that was a debt?
Yeah.
Have that conversation. If you have that conversation, then you can say, this child received 50K, his share of inheritance is reduced by 50K, or whatever the amount is.
If he has Islam.
I wouldn't leave it as a surprise because again, you don't want conflict after you leave. You want to leave things as easy, but that means we have to have difficult conversations, and we tend to know like really well. Again, cars, like insurance, retirement, all of those, you need to have your payroll on that or grantor on that. The last thing is just a wealth or endowment. It's a means to support for our Muslims and organizations. We have these wealth set up. We do not have to have fundraisers. There's some of the they can be that are probably really doors to witness. And they've been used in thousands of ways, including creative means, not just our massages in our schools, but hospitals, mental health facilities, farm animals. Once they were old and unable to work the farm, people used to have land for them to come and graze on. Students, research, a servant, if they accidentally broke a dish, we had old cloth that were set up where they could go and get reimbursed, right? And that's our history, right? We know that the oldest degree granting university in the world was created by, anyone know? A woman, a Muslim woman. Her name is Fatima al-Fahmy. It's at Al-Qarawiyya University. She received her inheritance. She built a university. It is the oldest degree granting university in the world today. Her sister built the masjid next door.
Wow.
That's their inheritance. Can you imagine, subhanAllah? And so that's what we need to be doing. Next steps. We talked about how this is taqwa, right? This is God conscious, having a will, having a trust. Make your intention right now. We know in all of our actions are judged by our intentions. make your intention, I'm going to do this, so I can follow my son's law, I'm going to do it as an act of worship, I'm going to do right by my loved ones, I'm going to do it to please Allah subhanahu wa ta'ala, I'm going to do it to make things easier for my family and my children. If you don't have a lot of time or money or anything, you can make a holographic will. A holographic will is a handwritten will that you write all of it down, you sign it and date it, you do not need witnesses, and if I go to sleep and I die tonight, I at least have something done, and I can say, Ya Allah, I did my duty. And I've got a picture of it on the next page, so take a picture of it, get it home, just handwrite it, and tell someone where it is. Gifting. What is my intent? What am I going to gift? Who do I want to give to? Make sure that you have non-employee transfers set up on all of your accounts. So property, vehicles, etc. So they pass outside of that court system. And you can also schedule a free consultation with me at abdullahoffice.com. And again, the holographic bill is valid about half the states, but it is valid in Texas. So it has to be fully handwritten. This is what it needs to create. These are the important sections of it. And you can put in, extra guardians, you can put in extra executors. If you want to, again, this is a stopgap until you do proper estate planning.
This can be contested, right?
Everything can be contested in court, but no, it's just, a will is just a telling the court, this is what I want to happen. I do include a no contest clause in my wills and trusts, meaning if you contest it, you get nothing. Not if you contest it by going to an imam, or no if you don't contest it by going to a mediator or going to talk to someone, but if you file a case to contest the will that I wrote or the trust that I created, you get nothing.
Islamic, that's fine.
That's valid.
Oh, shoot.
It's intimidation, huh? Some may argue.
What?
Some may argue that might be a bit of intimidation too.
What works? So again, children are our most important asset, and making sure that we have those guardianship documents, we listed out who we want to take care of them. You can also get like a standalone guardianship document, you can Google it and just fill it out, sign it and notarize it. Endowments are an essential part of our religion and an important way to safeguard the future for our children. Wills do not avoid probate, they do not avoid the court process, which is that long, public, costly process. Living trust will bypass that, and having transfer on death deeds on real estate, cars, bank accounts, retirement accounts, life insurance, etc. Reviewing all of your assets has to be part of your estate planning conversation. Want to make sure that Department of Unpaid Property does not get your money. And estate planning requires intentional action, right? We talk about infinite underhand. Being intentional, planning keeps you in control, keeps you informed, it gives you cost saving. Estate investment plan is not ideal for most families, it doesn't affect your dollars, it doesn't affect your children. Again, you can schedule a free consultation by coming to the website. What questions do you have for them?
Just a quick thing, it's 9:30, Isha's happening right now, the call is happening. So if you want, we could also pray the Jama'at here or or do the Q&A after Salah if you'd like.
I'm happy either way.
Yeah. So if you want, we could just go pray and then come back. It just started, the call. Yeah, are you open to?
I'm open to either one. I'm
Okay,
happy
we'll
with
do Q&A after Isha so we can do the Jama'at Masjid, inshallah. Just let's just try to come back soon and then we can pray the Sunnah of Isha at home or whatever, just so we can wrap this up quickly. Thank you.
Stop recording? Can you stop recording?
Yeah, yeah.
Okay, good. That way. If people want to come talk to me, they can talk to me without like.
Yeah.
Yeah,
Or
come
we
talk to me.
have to stop the live stream. Let me pause it.
Oh, so. So if you create a will in one state and you move to a different state, if it's valid in the state that you lived in, it will still be valid in the state that you moved to. There are nuances in each state, and so it might make sense to have someone review it. Not necessarily right away, but like if you have like major like changes, like I recommend that people like sit down and review it on a yearly basis and change whatever the assets there are. One thing I give my clients is a binder that has like 20 tabs in it. So not just a copy of the will or the trust or the financial power of attorney, medical power of attorney, healthcare directive, but as a place you put your tax return, all of your bank accounts, all of your any of your assets, and then I'm like, whenever you do your taxes, just update all of the statements so that your family knows exactly where everything is, and you tell them, this is the binder that has everything in it.
A second question, like if you're trying to navigate taxes and stuff, is it better to talk to that tax attorney first and then, or is that like something you can go to?
Again, if you are in Texas, unless you have over $30 million, you're not looking at estate taxes.
This is more like considering other states and stuff.
Other states do have laws, and so if you are not a Texas resident or you're moving away, that's when I would recommend.
So taxes first and then.
Sometimes they do both. Like there are attorneys that do both.
I know you explained this, but I'm still a little confused about it. From my understanding, I thought trust is always better than a will, but you said there are instances where wills are better. Can you elaborate on that?
It's not that a will is better. Even with a trust, I still create a will, but it's called a plural will. It tells the court if I forgot to put an asset into my trust, take it and put it into my trust. Right? So when I feel a trust is necessary if you have minor children, if you have young adult children who might need additional support, because you can write in, like, so for example, my kids, the trust, the way that I had it written is at 21, they received income, so there's any generating income. My son gets 2/3, my daughter gets 1/3 of it. At 25, they get 1/3. At 30, they get 1/3. At 35, they get the rest. The way that I'm creating trust right now is it actually splits it into two separate trusts for each of them. At the age of 30, they become a co-trustee. And then at 35, they manage that trust, and it becomes an irrevocable trust to them, meaning that if they are sued by a creditor, if they have they get divorced, that's the law, that becomes their separate property, and nobody has access to it. Right? And so there are other benefits to trust outside of the court process. The other big thing is making sure that, so my parents, for example, we created a trust, and right now I'm looking at dismantling that trust, creating a special trust for my younger brother, and then making sure that all of their assets pass outside of probate, because we know how things are going to go and everyone's sort of on the same page. Someone else has 6 kids, let's say they don't get along. You don't want just a will because you want one person in charge. Because if you can't all agree on what to do with an asset, you're going to court. And so when you have a trust, you appoint one person, they're in charge. They can do shootout and decide, okay, there's a home, nobody's living in it, let's rent it, let's sell it, and if everybody just, gets along, then they can do that. But you have one person who's in charge of making decisions and then backups.
You mentioned 3 types of trusts during your talk. You mentioned the revocable one, an irrevocable one, and a living trust. What's the difference between all 3, and would you recommend, or which type would you recommend?
So there's more than 3. There is the revocable and living tend to be very synonymous. They are very similar in the sense that I created it, you can create it for any purpose, and you need to allow who the beneficiary is. And the big thing is with the revocable or living trust is that I can change it. I can take everything out, I can get rid of the trust, I can change who the beneficiaries are, I can do whatever I want to. With an irrevocable trust, you cannot change it. So a lot of times I'll recommend an irrevocable trust with older parents, right? Because if they have significant assets, so Medicare covers health insurance if you're above 65. But Medicare does not cover long-term care. So if I have dementia, if I need to be in a rehab facility, those long-term care facilities can cost $10,000 a month and up. And so if you, to qualify for Medicaid, you have to spend down all of your assets. There are some exceptions, like you can have $700,000 of equity in your home. But a lot of times parents want to not have to have that concern. So they create an irrevocable trust. They put all of their estate in it, all of their assets in it. In 5 years, they qualify for Medicaid. So for long-term care. So sometimes older clients will do that instead. The downside to that is that you lose control. Whoever you appointed as trustee gets to make decisions about what happens to the assets inside. So I can't decide I want to sell my house after I put it into this irrevocable trust. Whoever appointed as trustee gets to make that decision for my benefit.
So to clarify, in a revocable and living trust, you can declare yourself as the trustee if you establish that trust.
I created it, I'm the trustee, meaning I manage it, and it's to my benefit, so I am the beneficiary.
And with the irrevocable one, an external party has to be the trustee.
Has to be the trustee, so they have to manage it to my benefit, but according to their own knowledge.
Makes sense.
So a lot of parents are like, no, I want to be control. How much does it cost to do all of this? Yes. And so if you're looking at a trust package, which includes your trust, whether it's revocable or irrevocable, depending, your revocable will, a financial power of attorney, medical power of attorney, healthcare directive, burial instructions, guardianship documents for me, guardianship documents for my kids. It includes a transfer of my property into my trust. It includes instructions on how to make sure that everything else goes into my trust. It's about $3,000 for an individual, $4,000 for a married couple. If you look at the will package, which is everything minus the trust, it's about half that price, about $2,000 or so. And that's starting, and so like if you have like 10 different assets that we're creating 10 deeds for, it will obviously cost more because we have to create the deeds and record them all. And that's a flat fee, meaning that it takes like 6 months to do this and you want to be with me like 5 times, then it's a flat fee. I won't come back and be like, you went with me 4 times for 20 minutes each, like your time is up. Both of you have questions, go ahead.
So like, whenever there's properties that are being added later on, is it possible to just frame it in such a way where you don't have to keep constantly updating the will?
You do not. The details about what's in the will or the trust does not write out what the documents are.
Yeah.
So when you buy a new property, you buy it in the name of the trust.
Oh, okay.
If you go to a new job, you make sure that you have your beneficiary designation listed as your trust.
Oh.
For your parent account, it's spouse and then the trust. For everything else, it's the trust.
Okay, and then my secondary question was, can you just like, for the holographic will that you had, can you just say like, I just want to do things like according to Islam or whatever, and like let's say you die, like
We live in Texas. Come on, dude, with anti-Sharia, really?
Yeah.
You want to tell that to a judge?
Yeah.
Red hair is fine. I'm a little bit more open. But I don't want to give them any ammunition, and so I want to write out as much as I can.
Okay.
And then there are calculators, if you can open up like an Islamic inheritance calculator, and you can like put in, I got 1 parent, I got 2 parents, I got a spouse, I got this many boys, this many girls, this many uncles, aunts, whatever, and it will tell you exactly who inherits. And again, this is a stopgap, this is not your permanent long term, this is to get until I either have more assets or I if I have a kid, then I need to do this revocable trust. If I, yeah, to stop that measure.
So when it comes to trust, if you do, like if you have your own LLC and you do work with that, right, as a contractor, does a revocable or irrevocable trust protect you from getting sued by like a client or anything like that? Or like does it protect, if you put your house in one of those, does it protect that asset from, like basically like lawsuits from a client or something like that?
So there are asset protection trusts that you can create that will create assets from it. Those do tend to be really expensive. But if you have a proper company, a proper limited liability corporation, where you are not dealing with funds. If I have an expense, I'm paying it for the business account. If I'm getting paid, I'm not putting it in my personal checking account, I'm putting it into my bank account, my business bank account. I have books, if I have created those formalities, then my personal assets are shielded as long as I wasn't negligent or I wasn't willful in what I did, then my personal assets are usually not attached. Sorry.
Sorry about that, guys. I know the microphone is.
Trying to just stay still. Any other questions? Any questions from online? I can't see the comments. You know if anyone asked online?
I don't know.
Okay.
I
Sorry,
have
folks.
two
Yeah.
questions. Okay, so let's say that you put an asset in a trust and someone files an insurance claim against you, right? Because that asset has been put in a trust, can the entirety of those assets be also like
Shielded or exempt. If it's an irrevocable trust and if it's listed as an irrevocable trust, then yes. If it's a revocable trust, no.
So everything can be impacted. So would you then recommend creating separate revocable trusts then for each asset?
No, because it wouldn't change. Like, if it's all owned by me, then it doesn't make a difference. If it's owned by one revocable trust or 10 revocable trusts, it's still my asset. But if it's like owned by an irrevocable trust, then yes, it is shielded from creditors. But those are like asset protection trusts.
Do any of these laws differ based on Islamic laws differ from the different schools of thought?
With regards to what?
To inheritance laws? Like, does it differ?
The verses in the Quran are clear, that is standard throughout. The only differences are like, again, like when it comes to Lucia, if I have any obligations to God, some of the madhabs say that it has to be written. If it's written, then it can be paid, otherwise it can't be paid. Under the Jafari madhab, which is the Shia madhab, you can equalize the estate without the permission, so you can give your daughters equal to the sons without having any issues. They're also a little bit more progressive in the sense that like community property, they're like, yeah, you own half, like as a woman, as a wife. Otherwise, you won't find differences with regards to the shares because those are Quranic and they're very clear and written. But you will find differences in scholars with regards to, the gifting, right? If you haven't, the gift hasn't been received, if you haven't recorded the deed, is it a gift or is it not? So you will have questions in that from different scholars, you'll have different opinions there.
Thank you so much for your time. This was such an informative lecture. We appreciate your time, your work, and everything. May Allah bless you and your law office and everything you do.
جزاكم الله خير سبحانك اللهم وبحمدك أشهد أن لا إله إلا أنت أستغفرك وأتوب إليك بسم الله الرحمن الرحيم والعصر